Hello, and welcome to Evolve Business with Boatima. My name, of course, is Boatima Boating. Special thanks goes to our proud sponsor, Chic by Siba. You can find Chic by Siba in East Legon. Calling, make sure you do, for all your Afrocentric clothing and accessories. Is anyone infringing on your literary or artistic work? Join us for this evening's episode on Evolve Business with Boatima. We are going to be discussing copyrights and how to protect them. Joining us virtually is Ms. Esther Kumsing. Esther is a practicing lawyer with expertise in IP and how to protect them. Hello, Esther, and welcome to Evolve Business with Boatima.
Hi, Boatima. Thank you for having me.
Okay, so I'm going to read our factual situation for today, and then we can just zoom right into our discussion. Dear Evolve Business, my name is Popia and I'm a businesswoman with a background in fashion designing. I usually design my clothing and send them to China for production. When they are ready, I inspect them and import them to Ghana for selling. My main mode of marketing my clothing line is through the common social media platforms. I pay for models or influencers to wear clothes from my shop for photo shoots, both at my expense. Sometimes I model the clothing myself. Then I post the images from the photo shoots to my social media platforms. Recently, I have noticed that some of my competitors are using pictures from my photo shoots to market their clothing. Sometimes they even use my own personal pictures too, all without my consent. I am really upset about it and I want to take legal action against them. They cannot reap where they haven't sown. What should I do? Esther, this sounds like an infringement of some sort of IP. What are your thoughts?
Absolutely. So basically, to summarize Poco's claim, she designs her clothes, she sends them to China if they are made, and then she imports them down to Ghana. And then she wears them, she also gets models to model them. They organize a photo shoot, which she paid for. And then when she gets those photos, she posts them online on social media. And she can see that people are actually taking these photos and just advertising them as if they were theirs without her consent. So basically her claim is grounded in copyrights, and copyrights is a form of IP, which is intellectual property. So intellectual property, we're talking about all creations of the mind, right? So it's more so like you having your car or say your laptop. Those are tangible assets. Intellectual property are intangible assets. So you sit down, you come up with something, you create, say, a book, right? You come up with a story, put it in the book, you do some sculptural work, name it. In Poco's case, she has designed, clothing. And all these are protected by copyrights.
Right. So Esther, now that you've spoken about intellectual property rights, what are some of the intellectual properties that we have?
Okay, so traditionally, intellectual property is grouped into two main branches, if you like, right? So we have the industrial property rights, and then we have the copyrights and related rights. So the industrial property rights, we are looking at patents, we are looking at trademarks, we are looking at geographical indications, we are looking at industrial designs, and those things. Now, when it comes to copyright and related rights, we are looking at works from, say, books. If you have database, computer, software, all those things. So copyright protects artistry works, it protects literary works, and those kind of works. And the related rights are basically those rights that aid the copyrights to be made available to the public. So you're talking about performance rights, you're talking about producers' rights, you're talking about broadcasters. So those are the rights that we term as related rights. So those are basically the main broad areas under IP.
Right. So from what you are saying, Pokia's claim will definitely be grounded as under copyrights.
Yes.
Okay.
Yes. So Pokia's claim, she's looking at the design of her clothing line, basically, and that is an artistic work. If you come to Ghana, that is classified as an artistic work, which is protected under copyright. In other jurisdictions, they may protect under industrial designs, but in Ghana, that has been put specifically under our copyright laws.
Okay.
So you design a piece of clothing, and somebody takes that design and reproduces it, or if it is through a photo shoot. So in her case, she pays for the photo shoot, and then she puts the pictures on her social media handle. Now that's another lane, because this comes under commissioned works. So she has permission for the photos to be taken, and so she owns the copyrights to those photos because she paid for them. And this is different when, say, I see you and I take your photo, for instance, right? I took the photo of you, even though it is you, I took the photo, so I would own the copyrights to the photo. Unless somebody commissioned me to take that photo, then that person owns the copyright. It's also like if you are an employee, automatically, I mean, the laws of Ghana are clear. The employer owns any IP, in this case copyrights, that you come up with, unless there's a contract that speaks to the contrary.
Also, you're saying that if I'm an employee of a company, let's say a tech company, and then there's a software that I actually develop, is automatically the company who owns it, even if we don't have
Yes.
an agreement to that effect. The fact that I work for them and it comes within
Yes.
my duties.
Absolutely, absolutely. So it's within the scope of your employment. And so it is a presumption that it belongs to the employer unless you're able to prove otherwise. Now, you're only able to prove otherwise if the contract says otherwise, right? There was some agreement saying otherwise. Or you can prove that it was not within your scope of employment.
Right.
So I mean, let's take, for instance, I am a lawyer in a law firm. If I come up with a computer software, for instance, it is not part of my duties to design the computer software. So my employer cannot lay claim to that. But if I come up with any, say, written submissions, and I style it in a particular manner, and it becomes a precedent of the firm can easily use it. I don't own, any rights to it.
Right.
Yes.
Okay. So let's come back to Pokia's situation. So when does Pokia's right start?
Yes.
Is it when she designs the clothing? When does it start? And is it automatic, or when does it start and when does it end?
Yes. So that it's automatic for copyrights. So for copyrights, as soon as you come up with the work, it is given to you. So let's back up a bit. Let's define what copyrights are, right? You come up with a work, an original work. The work must be original, and then you must fix it. Fixing here means you must make a copy of it. In Pokua's situation, she actually designs the work, takes it out. It is made into a clothing. So when you look at the clothing, that her design has materialized into that. So she has fixed it. Another mode of her fixing it is the fact that she has actually taken pictures of it and posted it. So by taking the pictures of it, that is another way of fixing it, right?
Right.
And she says that she designed it. She designed it herself. You understand? So as soon as she designs it and then she fixes it so that somebody can also make a copy of it, which is a very important part of copyright. It's not just about your originality. That is why ideas, for instance, are not copyrightable. Idea belongs to you. Nobody knows the idea, or even if you speak about it without you talking about it to the public, for instance, nobody knows about it, so nobody can reproduce it. And copyright is an economic right, so there should be the possibility for somebody to perceive it, to be able to communicate it to the public or reproduce it before you can get that protection. So as soon as Pokua draws those designs, automatically she has fixed it, because now you can perceive it, you can look at, somebody can actually steal it, right? So as soon as she draws it, it becomes her copyright.
Right. So Esther,
copyright automatic.
Okay, sorry. What I was saying is that, so Pokia is saying that she's a fashion designer. Assuming she designs a cloth or a blouse that has 3 layers of, enhancements, okay, and then she doesn't even copyright it. Are you saying that the fact that she's drawn it, it becomes automatically hers, even if she doesn't register it?
Yes, she doesn't have to copyright it. The right is automatic. The only test is that, is it original and have you fixed it? At the point when obviously we are asking whether or not this work is original, we can take it for granted that it has been fixed, right? That somebody has actually can perceive it. Now, if she draws something with, you were talking about maybe 3 flaps, right? 3 layers. Is it original? Did she come up with it? Did she come up with that design? If she's able to prove that she came up with that design, and now in the fashion world, it's very difficult to prove originality because there's nothing that hasn't been drawn nowadays. You understand? So in terms of the protection starts as soon as the work is created and it is fixed. Then the protection starts. That is different from the other forms of IP, like patents, for instance. You need to actually apply for patent protection. You need to, if you talk about trademarks, for instance, trademarks, you need to apply for trademark protection, even though there are other laws that you can come under, like the Unfair Business Practices law, I believe. If you have used it for a while and you have some trademark, some goodwill in there, you can, seek some protection, but not under IP because you haven't applied for protection for trademark. A copyright is different. As soon as you create the work, you own the copyrights to it.
Right. Okay. It appears that Pokia is not so concerned about her designs going to China. Her main concerns are what she's actually putting effort to market and the fact that people are taking it. And she says she calls them her competitors. That means people who are in the clothing business, people who also sell clothes, are taking pictures, including her personal pictures, and then, posting it on their social media platforms, and should I say, passing it off as theirs, and trying to sell clothing, the same kind of clothing that she also peddles. Okay, so what have you got to say about that?
So let's take it from this angle, right? The main point here is the fact that she has commissioned for those photos to be taken. And so the photographers do not own the rights to the photos. She owns the rights to the photos. Now, the rights that copyright awards you or grants you is the right to exclude others from reproducing your work, importing and selling, all those things, right? And so the exclusive right, that's what I call exclusive right, is the right to exclude others from doing ABC without your consent. Right? So they are doing the things that they are doing without Pokua's consent. And the fact that she's able to claim that, she's able to prove that she owns the copyrights, it means that what they are doing obviously is infringing upon her copyrights. They are exploiting her work without her consent. Now, in relation to the fact that they are taking pictures from her page, some of the pictures are even her pictures. I think that the point is in the photographs. The photographs belong to her. So whether it is her photo or it is the photo of the models that she has, had to model the clothes or whatnot, they are all, under the same category. Perhaps when you talk about her photographs, you may be going into perhaps privacy rights, but when it comes to IP, the copyright is in the photographs. The fact that she, commissioned that work to be done and they are taking it without her consent. They need her consent. And that consent is usually granted through a license. She can license them to use the work for a particular purpose. That is how she can earn some money from it. Because, mind you, copyrights and all those other IP rights, they are all commercial rights. The only distinction is that with copyrights, the law adds another right, which is called the moral right.
Yeah.
So the moral right is just basically you being named as the author of the work. So even though you can license your economic rights, for instance, you cannot license your moral rights because that has been granted to you forever. That is in perpetuity. You cannot license that away.
Right. So Esther, you're saying that the moral right is more like giving recognition to, in this instance, of Pokia, that she actually got those photos to be made for her and they belong to her. And because they belong to her, she has the right to exclude others from using it. Right.
Absolutely.
Okay. What if someone she grants someone a license to use it? Okay, this is not part of her questions, but what if she grants someone a license to use it and the person wants to use it for let's say something that she doesn't agree on? Let's say there's a new movement of some sort coming up or something religious that she doesn't agree on. Will she have does her moral rights cover the fact that she can stop these people from using it for purposes that she agreed to, or things that are different from or aligned with her values, things that don't align with her values?
Right. Right. So that is why this is contract 101, right? That is why you have to put everything in the contract, because a license is a form of contract. So if you don't want your work to be associated with any kind of affiliations, whatever it is, you need to put it in the contract. And that is why it is very important when you are dealing with IP to seek out counsel. You seek advice. Those who are really well versed in the area of IP, who can really advise you as to what to watch out for, what to look out for, and what to do, what to put in the contract. Because as I said, there are some presumptions here and there. You need to be able to, a lawyer or whoever you seek out should be able to advise you properly and say that, hey, if these are things that you feel very strongly about, you should probably put it in there. You understand? So you cannot automatically, after you've licensed it without putting in those fine details, now come and say that, hey, I don't want you to put my work here, put my work there. If you want to restrict the person, you do that in the license, in the contract.
Okay. All right, great. So how long can a copyright be protected for? Assuming, Pokia, I'm not trying to kill you, but assuming Pokia is no longer alive,
yeah.
I mean, who will own it and how long will that, because you know how our sole proprietors work, the business dies, the life of the business ends with the life of the proprietor. Okay, so assuming Pokia is no longer alive, okay, how long will that copyright be protected?
So copyright, that's the amazing thing about copyright. Copyright is granted to you for the entirety of your life, so for the lifetime of the author, plus, in Ghana, plus 70 years.
70 years?
Even 70 years after the person, yes. 70 years after the person is gone, you can still, so the person's beneficiaries can still claim the royalties that, are attributable to the work. And then after 70 years, the work falls into the public domain and everybody can use it.
Oh wow! So let me go outside our factual situation again. So let's take music by Terry Bonchaka. I mean, we miss him. May he continue to rest in peace. But are we saying that Terry Bonchaka's music, his beneficiaries or personal representatives will have it protected until 70 years after Terry Bonchaka's death?
Yes, absolutely. But the other question is that in our parts of the world, a lot of people don't appreciate IP. A lot of people don't invoke or enforce their IP rights. So I wonder if the radios, radio stations playing his music. I haven't heard his music in a while though, but I'm sure there are other people who continue to play. People are probably have reproduced the work probably on CDs and are renting them out. I don't know, maybe even online, maybe on Spotify and all these streaming sites. I'm sure people are still playing it. Whoever the royalty, he should be entitled to, his estates, right? His beneficiary should be entitled to some money, some royalties, but as to whether they are taking advantage of it, that is another story. Yeah.
Wow. Okay, so let me take you back to our pictures. Okay, so the issue of the pictures.
Yes.
In this instance, Hokia has commissioned someone to take their pictures. Assuming you and I, or you invite me for a party, and we are there, and someone just takes their phone to take a picture of me. And these days, our smartphones are able to automatically filter the pictures and take out the blemishes of my face and post it on their social media platform. Are you saying that they are not supposed to at least ask for my permission before they do that?
They don't have any obligation. As far as IP is concerned, right? As far as intellectual property, you don't have, and I had a heated argument with one of my bosses on this the other time. And he found it very hard to believe that he doesn't have any intellectual property in his face, in his face per se. You don't have any, when it comes to IP, the person takes their photo, they decide whether to use portrait mode, whether to use the normal mode. They decide on all these things before they take the picture. That artistry process is what IP is protecting, right? So after that artistry or artistic, I think it's artistic, right? After that artistic process, whatever comes out is the photo. You understand? Now IP is interested in that creative process. IP wants to engender innovation and creativity and all that. You understand? So IP is protecting that process. So it is the person who takes their phone to do all those things to get your image. They own the rights. They don't need your consent to do that. And privacy rights, I mean, it depends from, on the particular jurisdiction that you are in. EU privacy rights, totally different from US privacy rights. Some of them are best relaxed, others. But when we are coming to IP, we're talking about IP, is the person who takes the photo, they own the copyrights.
Wow.
It's hard for people to appreciate that, yeah, it's my face. Yeah, it's my face. But image rights and privacy rights are not, they are distinct from IP.
Okay. So what if at the same party, I have a drink, let's say you've started a side hustle, and it's Esther Special Drinks, and I have a bottle in my hand, and then before I know it, there's a billboard with me holding Esther Special drink in my hand, and this one is for commercial purposes. Even that one, are you saying that they don't have to ask me for anything because they took the picture?
So, yeah. So here there are a lot of rights at play, right? You are holding the drink. The bottle of water, you said it was special ice, right?
No, I'm saying Esther Special. I said Esther Special drink.
So Esther Special, right? Now, let's assume Esther Special is a business, because that's where you always have.
Yes, I said it's your assuming you invited me to the party and it's your side hustle. So I get there and I see these beautiful bottles with Esther Special drinks, and I just grab one, and I'm standing there and then feeling all frisky at the party. There's a picture taken by you or your photographer, and then before I know it, there's a billboard out there with my picture, me, standing there holding Esther Special. You haven't asked for my permission and you're using it for a commercial purpose.
Exactly. So here, when we are talking about IP, the rights which would be at play here, first of all, there's the Esther Special logo on there, right?
Yes.
Now, the logo on there, if it is not protected by trademark, then you come under the Unfair Business Practices Act, where you're actually passing off somebody's trademark as yours, for instance. And I actually had a case like that, where there was a different entity that was selling products of my client. So customers will be going to buy thinking it's coming from a particular producer, not knowing that it's coming from another person. And that is where, trademark comes in. It's just to distinguish one business from the other. Now you are holding Specialized, there's this trademark there. Because I am actually the owner, right? I am actually the owner of Specialized, isn't it? It's my side hustle. I can sue them for passing off my business as theirs. So that is one leg of the argument, right? Now, in terms of your picture, you would have to come up with some argument other than grounded in IP, because the picture was not taken by you. So it's either they are marketing your face, with the picture. If perhaps you are a celebrity, for instance, and those are other legs that levels that you have to actually deal with. Because if you're a celebrity,
Not yet.
then
Not
if
yet.
people see you as associated,
Not yet.
lawyers are not celebrities. How will you?
Not yet,
So,
Esther.
right, very soon though, very soon though.
Hopefully.
You know, so so if you're a celebrity and you are associated with that company, because obviously now that company is not Esther anymore. That company is another company pretending to be Esther, right?
Okay.
Now the celebrity, because it's going to boost the sale of this person, and this celebrity probably also has a lot of endorsement deals, it is going to perhaps affect her trademark. She has a company. She has a company, perhaps maybe a company that is also into the same mineral water, or even another kind of work, which perhaps she has some contract saying, hey, you are not allowed to advertise any other brand apart from my brand. Then she can have a claim, you know, under unfair business practices, you know, saying that this person is passing off something that does not actually belong to. So those are the issues that you look at. But when it comes to IP, it is only the work that are protected in there that you can sue for. So you have to be very particular about, you know, all these things.
Right. So Esther, back to Pokia's situation. What are her remedies, if any?
Yeah, so her remedies, obviously these people are exploiting her copyrights. So she can sue them, you know, for damages. You know, she can sue them for damages because, and so far as she can prove that their work belongs to her, and as we already said, she's commissioned it, it belongs to her, she can sue for damages. She can go for an injunction, you know, to prevent this person from, you know, continue to keep this on their social media, you know, handle. So the injunction, a takedown, you know, order where they actually have to take down this picture. Yeah, and in fact, even in Ghana, there are situations where you can actually, the law allows you to, you know, go the criminal way and actually apply for somebody to, you know, be in prison. Because those are also, if you infringe on somebody's copyright, you know, you may be liable to a term of imprisonment, to fines. Obviously, those are the criminal aspects. And then you have the civil remedies also, which is what I mentioned. You know, you go for an injunction. Usually injunctions, if there's a threatened, you know, you get when the fact that somebody's threatening to do that, then you go for an injunction. If it's already up there, you go for a takedown order where the court will instruct this person to take it down and pay you some damages that you have suffered, and obviously damages would have to be assessed, you know, in terms of what you are entitled to.
Wow.
Yeah.
So as you said earlier, copyrights are automatic. Okay. But what if I invent, or back to Pokia's situation with her enhanced 3-flap blouse? What if another person also designs the same thing and that person goes to register it first? How will Pokia be protected?
That is a very, very, very good question. So the thing with copyright is that copyright allows for independent creation. So it doesn't matter that you have created. It doesn't matter that somebody else is already out there. And that is what distinguishes copyright from other IP rights like trademarks and patents and those other things, right? So far as you independently designed the work, you did not copy, and you can show that was your independent creation. And as I said, a lot of these things have been drawn. You know, people are drawing all sorts of things. The fact that you haven't seen it doesn't mean you are the one who first, you know, came up with this design or whatnot. So copyright allows for independent creation. What you need to prove is, so if there's somebody who has also, this person comes out and says that, well, the design doesn't belong to you, I also independently designed it. This person has to prove that indeed I did not, you know, she did not copy, you know, Pokua, right? She has to prove that she did not copy. And there are so many ways to prove. You can prove by circumstantial evidence, maybe. But now in this internet age, it's difficult to prove those things, isn't it? Because designs here are getting to China everywhere. Because when you put something on the internet, it just goes. But yes, another person can also create it. And if you go and register it first, as I said, registration of copyright just gives you the presumption of ownership, right? It's easier when you go to court to show that, okay, I've actually registered this design. But it doesn't take away, the fact that you have registered it doesn't mean that no other person can independently create it. It just makes your work easier, proving that you own that copyright. That is pretty much it. And then that person has now the burden to prove that they didn't copy your design.
So really and truly it puts you in a better position if you've registered it, right?
It puts in and I would advise people to do that. I would advise people to do that they should. And right from the start, when you think of an idea, when you think of an invention, when you think of creating something, seek out a professional, let them manage it for you, because you can actually be earning some fine money, without, a lot of nowadays people just take people's pictures, they post it without any attribution. They don't attribute that, they don't state that this picture belongs to this person, no acknowledgements, no nothing. They just take it and pass it off as GS. All these things, you can earn some pretty good money.
Wow. So how expensive are copyrights to register? And how easy is it in the first place?
It's actually very easy. I think sometime last year I did some inquiries on that, because I got a couple of clients who wanted to register. One wanted to register their translation of a Bible into the Twi language. The other one wanted to register a song, and it's actually very, very straightforward and not so expensive. I think the registration is about 60 cedis or so, another 2 years or so. You just have to give them copies, I think 3 copies, and then it's not expensive, not at all. Maybe the legal fees would be expensive, but the actual registration, is not expensive.
Thank you so much, Esther. We've learned so much. And thanks for your time. Now, viewers, you have heard Lawyer Esther. You've got to know your copyrights, know what your literary artistic works are, your creative works, and have them registered. It's actually in your interest to do that, to avoid situations like these. As Esther rightly said, if you have your copyright infringed upon, there are remedies under the law for you to do it. Speak to the right people. Speak to a lawyer who's trained on IP or in IP rights. So viewers, thank you so much for joining us for tonight's episode of Evolve Business with Boateng Boateng. Special thanks, of course, goes to our proud sponsor, Chic by Siba. If you need any Afrocentric clothing or accessories, call in at Chic by Siba in East Legon.